Am I
Yes,
clearly
ma'am.
audible?
Yeah, yeah. Yes, ma'am.
Whenever there is a checkered communication from me, please stop me. I can repeat, okay? Because I think the connection is little iffy, but that's okay. Okay?
Sure, ma'am. Yes, ma'am.
Explain the law relating to child labor in India with the help of decided cases. This has been repeated 6 times in the past few years. So this is about the law relating to child labor in India. Salient features of Child Labor Protection and Regulation Act 1986. Comprehensive prohibition of child labor is the first salient feature. The Act prohibits the employment of children below the age of 14 years in all occupations and processes. This is a significant expansion from the earlier provision that prohibited child labor only in hazardous occupations. So, in earlier acts, children were only prohibited to be engaged in hazardous occupations like firecrackers or some other glass industry, all this. But after Child Labor Prohibition and Regulation Act 1986, all children below the age of 14 years cannot be engaged in any occupations. They have to go to school. Definition of child and adolescent. Child, defined as a person who has not completed 14 years of age. Adolescent, defined as a person who has completed 14 years but has not completed 18 years of age. So that is the second definition that was formulated in this act. The third salient feature is prohibition of employment of adolescents in hazardous occupations. So the act prohibits the employment of adolescents in hazardous occupations or processes specified in the schedule. So there must be a schedule, and we will get to it. But there are a list of occupations and processes that are specified in the schedule, and the act prohibits employment of adolescents in those occupations. The central government is empowered to add or modify the list of hazardous occupations. So the central government has a prerogative. Exceptions to prohibition is the fourth salient feature. The prohibition of child labor does not apply in the following cases. Number one, where a child helps her family in family-based work, provided it is not in a hazardous occupation and is done after school hours or during vacations. So that is not considered child labor. Second thing is where a child works as an artist in the audio visual entertainment industry, including advertisements, films, TV serials, provided their education is not affected and safety measures are in place with the district magistrate's permission. So district magistrate permission, safety measures, and education is not affected. If these three conditions are fulfilled, the child can work as an artist. We see young artists, kada, those people. Regulation of working conditions for adolescents is the fifth salient feature. For adolescents employed in non-hazardous occupations, the Act regulates their working hours and conditions to ensure they are not exploited and their education is not hampered. This includes prescribed hours of work, not exceeding 6 hours a day, including 1 hour of rest. So 6 hours, including 1 hour of rest, is what is the prescribed hours of work. No work between 7 p.m. and 8 a.m. and a weekly holiday. These three conditions have to be fulfilled to engage adolescents in non-hazardous occupations. Sixth salient feature, enhanced penalties for violations. So if any of the above things are violated, there are penalties that have been enhanced from the previous act. The act prescribes stricter penalties for employing children in violation of its provisions. The punishment includes imprisonment for a term not less than 6 months, extendable to 2 years, and fine not less than 20,000, extendable to 50,000, or both. So imprisonment plus fine, or one or the other. Repeat offenses attract even higher penalties. Cognizable offense. Offenses committed under this act are now cognizable, allowing the police to take action, register FIR, and investigate without a warrant. So without a warrant, they can arrest and investigate, register an FIR. Child and Adolescent Labor Rehabilitation Fund has been incorporated under this act. The act mandates the establishment of a rehabilitation fund in each district to provide for the welfare and rehabilitation of rescued child and adolescent laborers. Fines realized from employers are credited to this fund, and the government is also required to contribute a specified amount for each rescued child and adolescent. In practice, this fund is completely empty in all the districts. At least in Telangana, I can say that. Duty of the government. The Act places a responsibility on the appropriate governments. The Act places responsibility on the appropriate government, central or state, depending on where the thing is, to take necessary steps for the effective implementation of the Act, including conducting surveys, inspections, and awareness programs. Power to make rules. The appropriate governments are empowered to make rules for carrying out the provisions of the Act, such as prescribing the hours of work for adolescents, health and safety measures, and procedures for the rehabilitation fund. In all these aspects, the state or central governments have the power to make rules. So these are the 10 salient features of the Act. Next, key provisions of the Child and Adolescent Labour Prohibition and Regulation Act 1986. Definition of the child and adolescent. Child, a person who has not completed 14 years of age. Adolescent, a person has completed 14 years but has not completed 18 years. Prohibition of employment of children. This is the repetition kadandi Venu garu.
Yeah, it's somewhat repetition, and I think the question ఒకసారేమో salient features అన్నారు, ఒకసారేమో key provisions అన్నారు.
కాదు, యాక్ట్ కూడా డిఫరెంట్ ఏమో కదా.
Sorry ma'am.
First act ఏమో Child Labor Prohibition and Regulation Act 1986. ఇదేమో Child and Adolescent Labour Prohibition and Regulation Act 1986.
Child Labor ఇది సేమ్ కదా మేడం. Prohibition 1986 ఒకటే యాక్ట్.
అవునా? కానీ అడోలసెంట్ లేబర్ అని ఉంది దీంట్లో. కీ ప్రొవిజన్స్ ఆఫ్ చైల్డ్ అండ్ అడోలసెంట్ లేబర్.
ఐ థింక్ చైల్డ్ అండ్ అడోలసెంట్ లేబర్ రావాలనుకుంటా. బట్ ఇట్స్ ద సేమ్ యాక్ట్ 1986 యాక్ట్.
అవునా? ఓకే.
ఒకటే యాక్ట్ ఉంది.
సో అడోలసెంట్ ప్రొహిబిషన్
బేసికలీ ఏంటంటే ఒకసారేమో వాళ్ళు సైలెంట్ ఫీచర్స్ అడిగినట్టున్నారు, ఒకసారేమో కీ ప్రొవిజన్స్ అడిగినట్టున్నారు. సో ఇట్స్ ఆల్మోస్ట్ ద సేమ్.
It's same. ఈ పేజ్ లో వరకు సేమ్ ఉంది. నెక్స్ట్ పేజ్ ఎల్సి పేరెంట్స్ అండ్ గార్డియన్స్ ఆర్ నాట్. సో ఇక్కడ కొంచెం ఉంది. పెనాలిటీస్ ఫర్ కాంట్రవెన్షన్ ఉంది కదా. ఇంకా పెనాలిటీస్ ఫర్ కాంట్రవెన్షన్ లో 20,000, 50,000 ఆర్ 50,000 ఇంప్రిజన్మెంట్ అది పోతుంది. తర్వాత ఫర్ ఎంప్లాయింగ్ అండ్ అడోలసెంట్ ఇన్ హజార్డస్ ఆక్యుపేషన్ ద పెనాలిటీస్ ఆర్ సిమిలర్. సి అడోలసెంట్ గురించి స్పెసిఫిక్ గా చెప్తోంది సబ్ ప్రొవిజన్ యాక్చువల్లీ. ఇక్కడ ఫర్ ఎంప్లాయింగ్ అండ్ అడోలసెంట్ ఇన్ హజార్డస్ ఆక్యుపేషన్స్ ద పెనాలిటీస్ ఆర్ సిమిలర్. ఓకే. తర్వాత రిపీట్ అఫెండర్స్ అది ఉంది. తర్వాత పేరెంట్స్ ఆర్ గార్డియన్స్ ఆర్ నాట్ లయబుల్ ఫర్ పనిష్మెంట్ ఫర్ ద ఫస్ట్ అఫెన్స్. ఫస్ట్ అఫెన్స్ కి పేరెంట్స్ అండ్ గార్డియన్స్ ఆర్ నాట్ లయబుల్, బట్ ఇఫ్ ద అఫెన్స్ ఇస్ రిపీటింగ్ దెన్ దే బికమ్ లయబుల్. Next thing is cognizable offense. Offenses under this act are now cognizable, meaning the police adi undi kada, the police can arrest without a warrant and investigate. Child and Adolescent Labour Rehabilitation Fund. The act provides for child and adolescent labor rehabilitation fund in every district anundi. The government may also contribute an amount of 15,000 for each child or adolescent rescued to be deposited in a bank account in their name.
Okay.
Ante
only the second, madam, the డిస్టింక్షన్ ఏంటంటే సెకండ్ దాంట్లో మనం అడోలసెంట్ గురించి కూడా చెప్తున్నాం. ఫస్ట్ దాంట్లో ఓన్లీ చైల్డ్ గురించి చెప్పాము.
ఎగ్జాక్ట్లీ.
ఇక్కడ అడోలసెంట్ అంటే అడోలసెంట్ ఏజ్ ఏంటి, వాళ్ళ వర్కింగ్ అవర్స్ ఏంటి, వాళ్ళు అసలు హ్యాజర్డస్ ప్లేసెస్ లో వర్క్ చేయొచ్చా లేదా, మైనింగ్ లో వర్క్ చేయొచ్చా లేదా, మోస్ట్లీ ఫోకసింగ్ ఆన్ అడోలసెంట్స్. ఇది ఇక్కడ ఎక్కువ అడోలసెంట్ మీద ఫోకస్ చేస్తాం.
కరెక్ట్. దాంట్లో గవర్నమెంట్ షుడ్ కాన్షియస్లీ కాంట్రిబ్యూట్ 15,000 ఫర్ ఈచ్ చైల్డ్ ఆఫ్ రెస్క్యూడ్ అడోలసెంట్ చైల్డ్. అది టు బి డిపాజిటెడ్ ఇన్ ఎ బ్యాంక్ అకౌంట్ ఇన్ దేర్ నేమ్. ఇది నార్మల్ 14 year బిలో చైల్డ్ కి ఆ ప్రొవిజన్ లేదు.
సో ఐ థింక్ ద వే వి షుడ్ రీడ్ ఇట్ ఈస్ ఫస్ట్ చైల్డ్ గురించి రాసి కింద అడోలసెంట్ గురించి రాయాలి. అది జస్ట్ హెడ్డింగ్స్ మైట్ బి లిటిల్ ఆఫ్.
No, I think ఒకసారి చూస్తా, అది బేర్ యాక్ట్ చూస్తా, చైల్డ్ అండ్ ప్రొహిబిషన్ రెగ్యులేషన్. ఐఎమ్ షూర్ దాని కింద ఒక సబ్ క్లాజ్ అడోలసెంట్ గురించి కూడా ఉంటుంది. సో we should, when they are talking child, anyone below 18 years we will consider child, but it will be divided into two portions. One is below 14, one is 14 through below 18.
Actually the act పేరే చైల్డ్ అండ్ అడోలసెంట్ యాక్ట్. పైన తప్పు రాసాం, ఒకటే యాక్ట్ ఉంది.
Okay.
I'll send you the Bail Act. Yeah.
Okay.
నెక్స్ట్ పార్ట్ లో ఉంది సార్ కాన్స్టిట్యూషన్ అని చెప్పి లా రిలేటింగ్ టు చైల్డ్ లేబర్ ఇన్ ఇండియా ఆఫ్టర్ దిస్ ఇమీడియట్లీ ఇట్ ఈస్ దేర్.
ఉంది ఇక్కడ.
Yeah.
See, I think అంటే this is my guess. Child Labor Prohibition and Regulation Act 1986 వచ్చిన తర్వాత దీన్ని 2016 లో అమెండ్ చేసి అడోలసెంట్ పదం కలిపారు.
కరెక్ట్.
ఎందుకంటే చిన్నప్పుడు చదువుకుంది చైల్డ్ లేబర్ ప్రొహిబిషన్ రెగ్యులేషన్ యాక్ట్ 1986 ఈ అమెండ్మెంట్ తెలియదు నాకు. Okay. So the law relating to child labor in India, the concept is child labor refers to employment of children below a certain minimum age in work that deprives them of their childhood education and is harmful to their mental and physical development. In India, protecting children from labor exploitation is both a constitutional mandate and statutory obligation. So major constitutional provisions emunnayo cheptunnaru. Article 24, which is one of the fundamental rights, prohibits employment of children below 14 years in factories, mines, or any hazardous employment. Article 21A guarantees free and compulsory education for all children aged 6 to 14. Article 39E and F directs the state to ensure that children are not forced by economic necessity to work unsuited to their age. This is directive principles of state policy. Statutory laws ఏంటంటే Child and Adolescent Labour Prohibition Regulation Act 1986 as amended, also amended in 2016. Completely prohibits employment of children below 14 years in any occupation, allows adolescents 14 to 18 years to work only non-hazardous occupations. తర్వాత ఇంకో స్టాట్యుటరీ లా ఏంటంటే ఫ్యాక్టరీస్ యాక్ట్ 1948 prohibits employment of children below 14 years in factories. Mines Act 1952 prohibits children below 18 years from working in mines. So violation of any of these laws attracts penal action. So mines okati, factories okati, then in any hazardous occupations, 14 years aithe in any occupation. Adi. So relevant case laws, famous MC Mehta versus State of Tamil Nadu. The Supreme Court directed the formulation of schemes for the rehabilitation of children working in hazardous industries like match and fireworks factories in Shivakasi. This is famous, right? It held the employment of children below 14 years in hazardous occupations violates Article 24 of the Constitution. The court mandated compensation, education, and alternative employment for the affected families, laying the groundwork for active judicial intervention in child labor issues. This is very famous case from Shivakasi actually. There was a lot of protests that happened during that time.
Yeah. MC Mehta garu మొత్తం he won some golden environment award also కదా for landmark judgments in India.
Golden Globe environment, golden environment something ఏదో ఉంది దాని పేరు. Golden, I don't remember.
మీకు కూడా అలా ఇస్తారేమో మనం సోషల్ సర్వీస్ లో.
వద్దులేండి, ఇక్కడ ఉంటే చాలు నేను ఇంత.
ఓకే ఓకే.
Next case law is People's Union for Democratic Rights versus Union of India. The court ruled that acceptance of employment by children or bonded laborers for less than minimum wages amount to forced labor under Article 23. The court ruled that acceptance of employment by children or bonded laborers for less than minimum wages amounts to forced labor under Article 23. This is stupid, kada? The court stated that economic necessity cannot justify such employment. It emphasized the duty of the state to eliminate child labor by providing economic alternatives to families, reaffirming constitutional protections against exploitation. అంటే ఫస్ట్ స్టేట్మెంట్ నాకు అర్థం కాలే. అంటే మినిమం వేజెస్ ఇస్తే పిల్లల్ని పెట్టుకోవచ్చా పనిలో?
లేదు, ఐ థింక్ అది నాకు తెలిసి సుప్రీం కోర్ట్ కేసు ఏం వేసారంటే చైల్డ్ మినిమం వేజెస్ కన్నా తక్కువ ఇస్తున్నారు అని చిల్డ్రన్ కి.
అసలు చిల్డ్రన్ నే పెట్టుకోకూడదని చెప్పాలి కానీ
చిల్డ్రన్ అసలు మినిమం వేజెస్ కాదరా, ఫోర్స్డ్ లేబర్ కింద వస్తుంది ఆర్టికల్ 23 ప్రకారం సుప్రీం కోర్ట్ రూలింగ్ ఇచ్చింది.
I think we should assume that it is above 14 years.
Yeah.
14 years below, అది ఎలా పెట్టినా అది it is illegal.
Above 14 years and children and define చేయలేరు కదా అప్పుడు above 14 years అయితే కదా చిల్డ్రన్ అనే పదం వాడకూడదు కదా ఎనీవే సో దిస్ ఇస్ వాట్ ఇట్ ఈస్ సో we read about the salient features and of the child below 14 years, then 14 to 18 years adolescent, then we talked about the legal provisions and relevant cases. So you can take over from here, Venu garu.
Okay, sure, madam. So the next question is on the bonus and explain the conditions of payment and recovery of bonus under Code of Wages 2019. So question 5 times repeat అయింది. So basically ఏంటంటే as per the new Code of Wages 2019, the definition of bonus, which is under section 26, bonus means any additional remuneration in cash payable to an employee provided the terms of employment or any law, contract or instrument provide for such payment. So employment contract lo anna or law lo anna or any instrument lo anna ala bonus istamani ekkado chota raasi undali. That's what the definition says. It is important to note that the Code of Wages do not mandate payment of statutory annual bonus. Previous bonus దాంట్లో ఏంటంటే 1965 లో స్టాట్యుటరీ యాన్యువల్ బోనస్ ఇవ్వాలని ఉండేది, but the new code says that it does not mandate. However, it has given some guidelines. It says that terms of employment, and if the employee contract specifies payment of bonus, then as per law it should give. Next law, if any specific law mandates, then the payment of bonus should be given in certain sectors, or if there is a contract or an instrument between the employer and the employee. If there is separate agreement, then the bonus...
Increase your volume a little, please. Sorry.
Hello, ma'am, can you hear me?
Your volume a little bit. Yeah, I can hear you, but little bit faintly. So can you increase it a little bit?
Okay. You can hear me now? No problem? Yeah.
Yes, yeah. Yes.
Okay. So the Code of Wages doesn't mandate the bonus, and I think there are, however, it has given some guidelines. So basically, the guidelines indicate terms of employment. If the employee contract specifies, or if there is a law, specific law on the for payment of bonus for certain establishments or sectors, or if there is a contract or instrument between the employer and employees, then it is mandated for them to give the bonus. So conditions ఏంటంటే bonus ki, what are the conditions for payment of bonus? Given the definition, the conditions for payment of bonus under Code of Wages are primarily determined by the specific terms or legal provisions. Okay, these are: one, existence of bonus agreement policy. The employer has an existing policy, contract or agreement with employees or their representatives for the payment. This would typically specify eligibility criteria, the minimum working days or salary limits, so the formula or method for calculating the bonus or the payment schedule. Example, XYZ has a company policy that all employees who work for at least 30 days in a financial year are eligible for annual bonus equivalent to 8.3. So if they are specified in this way, then they have to pay that bonus. And second, applicability of specific laws. Certain specific laws might mandate the payment of bonus in a particular industry or for certain types of employees. In such cases, the conditions outlined in the specific law would be govern the payments. For example, the Code of Payment doesn't mandate, a specific state law for workers in a particular sector might require employers to pay a minimum annual bonus, like in sugar industry, where it is not a continuous thing. So if the sugar crop is well, then they might be mandated to give some bonus to the employees because it runs only for like 4 months. Third is fulfillment of eligibility criteria. If a bonus agreement or law exists, an employee would need to meet the eligibility criteria specified therein to be entitled to the bonus. Common criteria include completion of minimum number of working days, being on the payroll for specific duration, not being dismissed for certain reasons like fraud, misconduct, causing financial losses. So, for example, Rohan, who joined the company 6 months before the end of financial year and worked for 150 days, would be eligible for bonus, and he meets the minimum 30-day working for the bonus. Similarly, another example, Priya, who was dismissed for misappropriation of funds, might not be eligible for the bonus. Fourth one, profits or productivity. Some bonus schemes might be linked to the profitability of the establishments or productivity. The conditions for the payment would depend on achieving certain targets or profit levels. ABC Manufacturing announces a bonus linked to production targets. If the factory exceeds its annual production target by 10%, all eligible workers will receive an equivalent of 5% of their annual wages. So this is what are the conditions. I think there are 4 conditions which we have to remember for the exam. And then recovery of bonus. So recovery of bonus, you have to think from the employees side, like from the labor side. So for example, recovery of bonus, what it means is company promise చేసింది ఎలా మనం recover చేస్తాం as a labor, how do we recover the bonus from the company. So the code of wages treats bonus payable under any law for the time being in for are specially excluded from definition of wages. So one big drawback ఏంటంటే code of wages 2019లో వేజెస్ డెఫినేషన్లో మనం స్టార్టింగ్లో చదువుకున్నాం వేజెస్ డెఫినేషన్లో బోనస్ అనేది లేదు. So this bonus is excluded from the definition of wages under section 2y. This exclusion has significant implications for the recovery of the bonus. Since the bonus is not considered part of the wages, the mechanism for recovery of wages is provided under chapter 6 of code of wages. So what they say is basically what they're saying is you have to go for a civil dispute. Might not directly apply to the recovery of such bonus. However, the recovery of bonus might still be possible through other avenues depending on the basis of bonus payment. So what are the other avenues is basically recovery as per agreement or contract. If there is an agreement or contract with the company, if the bonus is payable on a contract or agreement, the employee fails, then they might need to file a civil suit for the breach of contract. And recovery under certain specific laws. So if specific laws are there, which might mandate it, unpaid bonus, then employees would need to follow the procedures laid down by the specific legislation. Act prakaram వాళ్ళు ఇవ్వకపోతే then they will fall, either it will be civil or criminal cases against them. So if a specific state mandates a festival bonus for certain workers and provides a mechanism for the recovery, employees should approach the authority for redressal if the bonus is not paid as per that act. So important considerations in the absence of general statutory bonus obligation and the exclusion of bonus from definition of wages in the code of wages represent a significant shift from previous legal framework. This is what Nirmala Madam has been talking about, that the code of wages is completely biased towards the companies and not for the laborers. And because there is a absence of general statutory bonus obligations. And then second is enforceability and recovery of bonus will now largely depend on existence and clarity of agreements, contract or applicable laws. Employees or employers need to be clear about the terms and conditions related to bonus payments outlined in their payments. So as per the contracts only, వాళ్ళకి బోనస్లు వస్తాయి, bottom line is. So these are some old relevant cases which were about the bonuses. The one was a workman of Raptco's Brett and Co. and versus manager. Supreme Court emphasizes that bonus is not a gratitude payment, but a legitimate right of employees rooted in the overall profitability of the organization. It ruled that while profit sharing is the basis, bonus must be also account for the need to ensure employees earn a fair wage that maintains a decent standard of living. The court stressed that bonus calculation must integrate the concept of fair wages and not just economic performance. Therefore, industries are duty to view bonuses as for the deferred wages than the judgment reinforces that principle. Basically, what they're saying is in this, the bonus, bonus profit sharing to link cheyandi antaru. Okay, and the court also said be humane. The judgment reinforced that. 1 minute, Andy. My car has been honking. Hello?
Yes.
Yeah, we can hear you.
Hello?
Yes, we are all here.
Yeah, sorry.
We are here.
My car was making that emergency noise. Okay. So basically, that's what it is. The judgment reinforces the principle that statutory schemes like payment of bonus should reflect broader constitutional ideals of social justice and equality. It safeguarded workers' interests against arbitrary denial of bonus. purely on technical profit calculations.
Ante
Okay.
this judgment was passed before the code of wages kabatti it will be different than what is stipulated in the code of wages.
Exactly.
Code for wages.
అంటే వాళ్ళు అప్పుడు ఫైట్ చేసి తెచ్చుకున్నారు దట్ బోనస్లు ఇవ్వాలి అండ్ కోర్ట్ ఆల్సో సెడ్ దట్ బి లిటిల్ హ్యూమన్ అండ్ గివ్ దెమ్ సమ్ మోర్ బోనసెస్ ఇన్స్టెడ్ ఆఫ్ జస్ట్ స్టికింగ్ టు ద నంబర్స్ క్యాల్కులేషన్స్. The second one was basically this Kamani metals and alloys and their workmen. This is an important case because Malli mana tarvata will study something called set on and set off under bonus laws. So previous laws ప్రకారం ఏమైందంటే బోనస్ క్యాల్కులేషన్ చేసేవాళ్ళు బేస్డ్ ఆన్ ద గ్రాస్ ప్రాఫిట్, సర్ప్లస్ ఎంత మిగిలిందో దాని మీద బోనస్ ఇవ్వాలి అని స్పెసిఫిక్ రూల్స్ పెట్టారనమాట. So in this case only there were guidelines for that set on and set off. So what it means is if in a particular accounting year surplus exceeds the minimum bonus payable, the excess must be carried forward to adjust for future shortfalls. This is set on. So meeku ee year ekku double vachinai ankondi, it says that money should be excess money can be carry forward for future shortfalls అన్నమాట. అంటే నెక్స్ట్ ఇయర్ మీకు ప్రాఫిట్ తక్కువ ఉంటే ఈ డబ్బులు అడ్జస్ట్ చేయొచ్చు, ఈ ఇయర్లో వచ్చిన ఎక్సెస్ డబ్బులు అడ్జస్ట్ చేయొచ్చు. సేమ్ థింగ్ if year there is no money to give bonus because the company didn't make much profits, then it can be carry forwarded to the next year. That is called set off. So these are the two concepts that have come in the Supreme Court guidelines, set on and set off. Then we separate short answers untai which we will discuss in detail. But just remember the case, because of this case only that set on and set off have come.
Oh.
That's why I highlighted that case. Okay. So in conclusion, the Code of Wages enables the payment of bonus based on specific conditions. Its exclusion from definition of wages means that standard wages recovery mechanism under the code might not directly apply. So the new code basically bonus doesn't apply. Recovery ఎలా చేసుకోవాలనే దానికి కూడా కాంట్రాక్చువల్ ఆబ్లిగేషన్స్ ఉండే చేసుకోగలం, లేకపోతే చేసుకోలేవు అంటారు more or less. Okay.
Okay.
Ma'am, can you continue question 6? I'll just my car sound
Yes.
chestunda, turn it off and come. Yeah.
Okay, but should I wait for you to come back or should I start?
No, please start. I'll just be back in 5 minutes.
Okay. So the next question is about the health safety. Any questions, Sarita, Hansika, or any other that are there on the call that we want to discuss in the bonus thing?
No, ma'am. I think we are good.
Okay, cool. So I am going through the next question answer. Discuss the law relating to health, safety, and welfare of labor under the Factories Act 1948. This has been repeated 3 times. So the Factories Act 1948 is a comprehensive piece of legislation in India that lays down detailed provisions for ensuring health, safety, and welfare of workers in factories. Its primary objective is to create a safe and healthy working environment and to protect workers from exploitation. So these are the key provisions. First one is health. The Act dedicates a specific chapter 3, to the health of workers, mandating several measures to ensure a hygienic and healthy work environment. First of that is cleanliness. Section 11 talks about cleanliness. Every factory must be kept clean and free from effluvia arising from any drain, privy, or other nuisance. This includes daily cleaning of floors, workrooms, staircases, and passages, regular painting or varnishing of walls and ceilings, proper disposal of waste and effluents. This includes cleanliness. Example, a textile mill must ensure regular sweeping and cleaning of the weaving and spinning sections to prevent the accumulation of dust and cotton fibers, which can be detrimental to the workers' respiratory health. Because these cotton fibers are very thin and the process of weaving, they keep breathing it, and once it's in the air, it keeps getting deposited in the lungs. A lot of people suffer from various diseases in this. Disposal of waste and effluents, section 12. So first, section 11 is cleanliness. Section 12 is talking about disposal of waste and effluents. Effective effective arrangements must be made for the treatment and disposal of waste and effluents generated during the manufacturing process to prevent pollution and safeguard the health of workers in the surrounding environment. For example, a chemical factory must have proper treatment plans to neutralize and detoxify chemical waste before discharging them, preventing soil and water contamination that could indirectly affect workers' health. So this is disposal of waste and effluents. Ventilation and temperature. So this is section 13, ventilation and temperature. Adequate ventilation and a comfortable temperature must be maintained in workrooms to prevent heat stress, suffocation, and accumulation of harmful gases or fumes. This includes circulation of fresh air, measures to control temperature and humidity. So in this, the example is in a glass manufacturing unit with furnaces generating high temperatures, the factory must install effective ventilation systems like exhaust fans and air coolers to maintain a tolerable working temperature for the workers. So this is about ventilation and temperature. The fourth in the health section is dust and fume, section 14, dust and fume. Effective measures must be taken to prevent the inhalation of dust, fumes, gases, etc. generated during manufacturing. This may involve enclosing the process ante kappipetti unchali process ni, so it doesn't spill out anything. Providing exhaust appliances near the point of origin. So that which at the point of origin, the gases should be sucked out through these exhaust systems. Supplying personal protective equipment like respirators. So example, workers in cement factory are exposed to significant dust. The factory must implement dust extraction systems at crushing and grinding units and provide workers with dust masks to prevent respiratory diseases. So the next one, Article 15, artificial humidification. In factories where artificial humidification is employed, the water used must be pure and the methods used must be hygienic to prevent the spread of diseases. So there should be certain humidity in the temperature, but in some work areas, it will be extremely dry. So there is a need for artificial humidification, but the water use should be clean because humidity is generated by water vapor methods, right? So the water use must be clean. Example, some textile factories use humidifiers to maintain yarn quality. The Act mandates regular cleaning and disinfection of these humidification systems. Overcrowding, section 16. Workrooms must not be overcrowded to an extent that could be injurious to the health of the workers. The Act prescribes minimum space requirements per worker. Example, a small workshop should not accommodate more workers than the permissible limit of area to prevent congestion and ensure adequate air circulation for each worker. So overcrowding is not allowed under section 16. Section 17, lighting. Sufficient and suitable lighting, both natural and artificial, must be provided in all parts of the factory to enable safe working and prevent eye strain. So that is lighting, section 17. Example, assembly lines in an electronics factory need adequate lighting to allow workers to perform intricate tasks accurately and without straining their eyes. Then drinking water, section 18. A sufficient supply of wholesome drinking water must be provided at convenient points, maintained in hygienic conditions and clearly marked. That there is drinking water area should be clearly marked. Example, water coolers or designated clean water dispensing units must be available at easily accessible locations throughout the factory. So water coolers or designated clean water dispensing units must be available at marked places in the factory. Latrines and urinals. Adequate and separate sanitary facilities for male and female workers must be provided, conveniently located and maintained in a clean and sanitary condition. This is section 19. For example, a large factory with a significant number of male and female employees must have separate blocks of toilets and urinals, regularly cleaned and with proper water supply. Spittoons. Sufficient number of spittoons must be provided at convenient places and maintained in a clean and hygienic condition. Spitting elsewhere may be penalized. Example, placing clearly marked spittoons in common areas and near workstations can help maintain hygiene within the factory premises. So under health, there are 11 through 20. 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. So under health, there are 10 sections, 11 through 20 in this act. As good to Poly. Then next section that they're going to talk about is safety. So this is health is talked in chapter 3 of the act. Safety is talked in chapter 4 of the act. Chapter 4 of the Factories Act 1948 lays down extensive provisions for ensuring the safety of workers and preventing accidents. So what are these? Again, 21 inches start ayindi. 21, fencing of machinery. All dangerous parts of machinery must be securely fenced by safeguards of substantial construction, constantly maintained and kept in position while the machinery is in motion or use. So dangerous parts of the machinery ki substantial construction to safeguard chali. Urke edo parda kapedamo atla kakunda. If there is a projection or if there is some hazardous thing that's likely to happen, then it should have some solid construction around it. It should be always maintained and kept in position while the machinery is in motion or use. Example, moving paths of lathes, power presses and conveyor belts must be enclosed with guards to prevent accidental contact by workers. That is fencing of machinery. Section 21. Section 22. Work on or near machinery in motion. Work on the machinery or near the machinery that is in motion. Examination or lubrication of machinery that is in motion is prohibited unless it is necessary and can be done safely by specifically trained personnel. So when the machinery is running, examining it or putting some lubricant into it is prohibited unless done by an trained person. Example, cleaning a running conveyor belt is generally prohibited unless specific safe procedures and trained personnel are involved. Third thing in this is section 23. Employment of young persons on dangerous machines. Young persons, by young persons, they mean below 18 years, must not be employed on any dangerous machine unless they have received sufficient training, are under adequate supervision, and are fully instructed on the dangers involved. So, these three things qualify, suffice avali. Sufficient training, adequate supervision, and they should be fully instructed. They should have complete knowledge of the dangers involved. Example, a 17-year-old trainee should not operate a heavy-duty power press without thorough training and constant supervision by an experienced operator. Striking gear and devices for cutting off power. Section 24. Factories must have efficient devices for promptly cutting off power from machinery in case of emergencies. Suitable striking gear or other efficient mechanical appliances must be provided and maintained. And if some power has to be cut off immediately to save some person in danger or to save short circuit, I don't know, whatever, then this should be in place. So they should have efficient devices for that. They cannot have age-old. Example, emergency stop buttons must be readily accessible near all machines to quickly halt operations in case of accident. Then fifth point, which is section 25, self-acting machines. Precautions must be taken to ensure that workers are not endangered by the movement of self-acting machines. Example, automatic robotic arms in a manufacturing unit must have safety sensors and barriers to prevent them from colliding with workers. So this self-acting machines. Then next thing is casing of new machinery, section 26. In all machinery driven by power and installed in a factory after the commencement of this act, all set screws, bolts, and keys on revolving shafts, spindles, wheels, and pinions must be so sunk, encased, or otherwise effectively guarded to prevent danger. So ఇవన్నీ కూడా లోపలికి బాగా లోపల కన్నా పెట్టాలి, లేకపోతే they should be sufficiently guarded so they don't tear into people's skin. This is casing of new machinery. Prohibition of employment of women and children near cotton openers, section 27. So section 27 talks about women and children near cotton openers. Women and children are prohibited from being employed in any part of a factory for pressing cotton where a cotton opener is at work. I don't know what is a cotton opener, but an opener is at work. Anyway, hoists and lifts, section 28. Hoists and lifts must be of sound mechanical construction, properly maintained and periodically inspected. They must have safety devices. Example, goods lift, goods lifts used in multi-story factory must have automatic locking mechanisms to prevent falls and regular safety checks. Okay, good. The lifts that take the goods up and down used in multi-story factory must have automatic locking mechanisms to prevent fall and regular safety checks. Lifting machines, chains, ropes, and lifting tackles. Section 29. I don't know how we'll remember all the sections. These must be of good construction, adequate strength, properly maintained, and periodically tested. The lifting machines, chains, ropes, and lifting tackles. Example, cranes used for lifting heavy materials must have their lifting capacity clearly marked, and their chains and ropes must undergo regular inspection for wear and tear. Precautions against dangerous fumes, gas, etc. Section 36. Under 29 నుంచి 36 కి jump అయిపోయారు. మధ్యలో 28, 29, 30 అవన్నీ ఏమైనాయో we don't know, but we'll see. Maybe they removed all those sections. Section 38. 36. Precautions against dangerous fumes, gases, etc. Section 36. Effective measures must be taken to prevent the accumulation of dangerous fumes or gases in confined spaces, and workers entering such spaces must be provided with appropriate safety equipment. Example, workers entering a storage tank must contain toxic fumes. Storage tanks that may contain toxic fumes must use breathing apparatus and have another person standing by for safety. Section 38. Precautions in case of fire. Factories must have adequate fire prevention firefighting equipment, means of escape in the case of fire, and regular fire drills. Example, fire extinguishers, fire hydrants, and clearly marked emergency exits are mandatory, and workers should be trained on evacuation procedures. So this training on evacuation procedure is a fire drill. 12th point. Section 40. Safety of buildings and machinery. Factory buildings and machinery must be of sound construction, maintained in a safe condition. Power to make rules to secure safety. Section 41. The state government is empowered to make rules prescribing further safety measures. So these are the things. Actually, this act comes into play with many times we'll see in TV or paper saying that this factory has been closed, that unit has been closed. These are the rules that they apply. Then the third section we are talking, first one is health, second one is safety, third is welfare. Welfare is dealing with the chapter 5 of the Factories Act 1948. What is welfare? Ensuring basic amenities and facilities are there. Anedi welfare. So this is chapter 5. Health is chapter 3. Safety is chapter 4. Welfare is chapter 5. Chapter 5, section 42. Washing facilities. Adequate and suitable facilities for washing must be provided and maintained for the use of workers, with separate provisions for male and female workers. Washing facilities. Example, providing wash basins with soap and clean towels or hand dryers near workstations and rest areas. Facilities for storing and drying clothing. Section 43. Suitable facilities for storing and drying wet clothing must be provided where workers are exposed to wet processes. Example, providing lockers and drying rooms for workers in a dye manufacturing unit. Sitting facilities. Section 44. Section 44. Suitable arrangements for sitting must be provided for workers who are obliged to work in a standing position to allow them to take rest whenever possible. Example, providing stools or chairs for workers on a long assembly line to use during breaks. First aid appliances. For section 45. Every factory must maintain properly equipped first aid boxes or rooms readily accessible during all working hours. The numbers and contents are prescribed based on the number of employees. Example, having first aid kits with bandages, antiseptic lotions, pain relievers, and trained personnel to administer treatment. These are all mandatory in an establishment. Canteens. Section 46. In factories employing more than 250 workers, an adequate canteen must be provided and maintained for the use of workers. The canteen must offer wholesome, hygienic, and affordable food. This is for 250 workers or more. A large automobile manufacturing plant must have a canteen with seating arrangements, a hygienic kitchen, and a menu catering to the workers' needs. Uh, the next one is restrooms and lunchrooms. In factories employing more than 150 workers, suitable restrooms or lunchrooms with adequate ventilation and comfortable seating must be provided and maintained. So canteens ki more than 250 workers, if restrooms and lunchrooms is more than 150 workers. This is spoken in section 47. Section 48. Freshers. In factories employing more than 50 women workers, it is suitable room or rooms for the use of children under the age of 6 years of such women must be provided and maintained. This includes providing trained attendants and necessary amenities. Example, a large garment factory with a significant female workforce must have a creche facility with toys, cots, and qualified caregivers. Welfare officers, section 49. In factories employing 500 workers or more, the employer must employ qualified welfare officers to look after the welfare of the workers and promote harmonious relations between the employer and employees. A major steel plant, for example, must have welfare officers who address workers' grievances, organize welfare activities, and ensure compliance with welfare provisions. So, inni gurtupeట్టుకోవాలి. Oh my God. Anyway, case laws. Again, MC Mehta is here versus Tamil Nadu. And yeah, the Supreme Court in this landmark case dealt with the employment of children in match factories operating under unsafe and hazardous conditions. The same case study, so which is good, at least we'll remember. The court strongly emphasized the obligation of industries to ensure the health and safety of all workers, especially vulnerable categories like children. It held that the Factories Act 1948 imposes safety of all workers, imposes mandatory duties on occupiers to ensure secure working conditions, adequate protective equipment, fire safety measures, and ventilation. The court also directed the state to ensure strict compliance with safety norms, warning that failure would attract constitutional liability under Articles 21 and 24. The judgment expanded the scope of right to life to include the right to a safe working environment, enforcing the Factories Act welfare objectives rigorously. So this, for the first time, incorporated right to safe working environment as a part of the fundamental right of right to life under Article 21. The next case study, Consumer Education and Research Center versus Union of India 1995 case. The Supreme Court in this case considered the occupational health hazards faced by workers in asbestos industries. The court ruled that the health, safety, and welfare requirements under the Factories Act must be interpreted broadly to guarantee a safe work environment. It recognized occupational diseases as a serious threat and imposed an obligation on the state and employers to provide periodic health monitoring, protective gear, medical insurance, and effective compensation for occupational health issues. So it talked about health monitoring, protective gear, medical insurance, and effective compensation. The court declared that the right to health is integral to right to life under Article 21, thus making the welfare provisions under the Factories Act not just statutory, but constitutional obligations. This is wonderful. Good. So these are all constitutional obligations. So anyone can go to court of law and fight for their fundamental right. So this is what it is. So conclusion, Factories Act provides for appointment of factory inspectors who are empowered to inspect factories, examine premises and records, and inquire into accidents and occupational diseases. The Act also provides or prescribes penalties for non-compliance with its provisions. In conclusion, this is the cornerstone of labor legislation in India, which is aimed at safeguarding the health, ensuring safety, and promoting welfare of workers. That is about this Act, which is the Factories Act 1948. So this
Okay.
finishes our third question. Any questions or discussions?
సో బేసికలీ ఫ్యాక్టరీ యాక్ట్ అంటే ఇవన్నీ గుర్తుంచుకొని రాయాలన్నమాట.
ఎస్. మీరేంటి ఇంత ఫస్ట్ సెమిస్టర్ సెకండ్ సెమిస్టర్ లో ఓపిక్ గా అది ఫస్ట్ లెటర్స్ అన్ని పెట్టి ఏదో మంచి వర్డ్ కాయిన్ చేసేవాళ్ళు కదా.
ఇంకా చేయలేదు మేడం, నా వల్ల కాదు, వదిలేదు.
అంటే మీకు కొంచెం చేస్తే మేము క్యామిల్ లాగా మా ఎక్స్పెక్టేషన్ పెరిగిపోతున్నాయి.
అవును. ఎంత ఎన్ని నోట్స్ రాసినా బుర్రకి ఎక్కించలేం కదా మేడం, అది మనమే ఎక్కించుకోవాలి.
అది కరెక్టేలే. అంటే ఆ యాక్రోనిమ్స్ ఉంటే ఈజీగా గుర్తుపెట్టుకునేవాళ్ళం, ఏదో తన్నుకొని ఆపే ఇది వచ్చిందా అని. బట్ ఎనీవే ఈచ్ ఆఫ్ us కెన్ కాయిన్ అవర్ ఓన్ యాక్రోనిమ్స్ అనుకోండి.
యా, ఎగ్జామ్ ముందు ఇప్పుడు గుర్తుంచుకున్న వేస్ట్ కదా మేడం. ఐ థింక్ మైండ్ లో యాజ్ లాంగ్ యాజ్ ద స్ట్రక్చర్ కమ్స్ ఇన్ టు ద మైండ్, యూ కెన్ జస్ట్ ప్లేస్ హోల్డర్స్ లాగా, దెన్ యూ కెన్ ఎగ్జామ్ ముందు ఇవన్నీ కొంచెం యాక్రోనిమ్స్ పెట్టుకుని యూ కెన్ లెర్న్ అండ్ బై హార్ట్. అండ్
అదే ఏముంది, హెల్త్, సేఫ్టీ, వెల్ఫేర్ ఈ 3 గుర్తుపెట్టుకొని చాప్టర్ 3, చాప్టర్ 4, చాప్టర్ 5 ఆఫ్ ద యాక్ట్ అని రాస్తే అక్కడ సగం మార్కులు పడతాయి. ఆ తర్వాత ఏదో ట్రైండ్
తర్వాత ఇంకా నచ్చింది రాసేస్తారు జనాలు.
అదే.
సో మేడం,
you want to do 7th or what?
we'll do
Very
it
big
tomorrow.
one. I know you'll say that. Okay. Yeah.
స్లోగా విల్ టేక్ ఇట్. ఎక్కువ చేస్తే మళ్ళీ నెక్స్ట్ డే రావట్లేదు జనాలు.
నిన్న కూడా 3 చేసాం, ఎక్కువ ఏం చేసాం బా. ఓకే, నో ప్రాబ్లం. ఇది కొంచెం పెద్ద క్వశ్చన్ కూడా రేపు చేద్దాం ఫ్రెష్ గా. It's also important, social security.
This one question